new here. I don't know how things work about employment. I don't know the employment policies and legislation in Cyprus. What are the things I need to know? How can I secure my rights in the workplace? So many questions and concerns. But don't worry. A guide regarding basic employment policies and legislation is here to provide you with important information you need to know to get you started with your employment rights in Cyprus. Before we start, it is important to be aware that your rights as an employee are determined from your status as a third country national in Cyprus. Domestic workers, students, and asylum seekers have specific eligibility criteria for employment and can only be employed in certain sectors. Recognized refugees have the same rights as Cypriot citizens to employment. Hence, there are no restrictions to any particular sector, and there is no need for the Labour Department to approve and establish a contract of employment between an employer and a recognized refugee. Beneficiaries of subsidiary protection have, as in the case of recognized refugees, immediate access to employment upon the date they are granted the aforesaid status. In particular, there are no restrictions regarding their employment in particular sectors or occupations of the labour market. Also, it is not necessary for the Labour Department to approve and establish a contract of employment between an employer and a person with subsidiary protection status. Let's take a look at some basic legislation. Employment terms and conditions. The employer is obliged to inform you as new employee about your basic employment terms and conditions such as the position, the type and the content of the job, the working environment, the contract start date and its expected duration in case of fixed-term employment, paid leave, as well as the procedure of granting such leave, the notice to be given by the employer and the employee in case of termination of the contract, all parts of the employee's remuneration as well as the frequency, the duration of the employee's normal daily or weekly work, any collective agreements applicable to the terms and conditions of the employee. The above information must be in writing and given to you within 30 days of your start date. However, the Cyprus labour law provides more specific employment conditions for certain professions, such as administrators, secretaries, caretakers, retail employees, etc. Legislation on salary and pay. It's important to know that the minimum wage for certain professions is set at €870 gross at the start of employment and at €924 after 6 months for professions such as sales assistants, school assistants, nursery assistants, etc. According to the Protection of Wages Law, wages must be paid at least weekly or monthly, depending on the agreement between the employer and the employee. Deductions from wages are permitted only under certain conditions and always to the extent deemed necessary. Every employer must provide equal pay for the same or equal value work regardless of employee's gender. At the same time, equal treatment and work obligation applies to full-time as well as part-time employees. Working hours. Working time in any week may not exceed 48 hours on average, including overtime. An employee is entitled to at least 11 uninterrupted hours of rest per day. When the working day is longer than 6 hours, the employee is entitled to a rest break of 15 minutes. During the break, the employee may leave his/her work. The rest break may not be granted at the beginning or the end of the working day. Leaves provided by law. Every employee is entitled to a paid annual leave of at least 20 working days for a 5-day working week and 24 working days for a 6-day working week. Other types of leaves that are provided by law are maternity, parental, paternity, and force majeure leave. Health and safety at work. Generally, there is a statutory obligation on every employer to ensure the safety, health, and prosperity at work of all employees and to ensure that every employee is provided with the necessary and sufficient training on this matter. Termination of employment. In case of termination of employment, based on the law, the party that takes the termination initiative must give a specific warning period. Employer's obligation to give notice. The notice period that the employer is obliged to provide to the employee in case of employment termination depends on the period of his continuous employment in the organization. Employee's obligation to give notice to the employer. The same applies in case of employment termination from the side of the employee. Note that usually the first 6 months are considered as probationary period and neither party needs to give notice for termination. However, the probation period may be extended to 2 years if the two parties agree to do so upon recruitment. Lawful and unlawful dismissal. It is important to be aware that not all dismissals are lawful. The criteria in order to determine whether the dismissal is lawful or unlawful are provided below. Lawful dismissal. An employer can lawfully dismiss an employee when the employee fails to perform the work in a reasonable, satisfactory manner, excluding the temporary inability to work due to illness, injury, or childbirth. Of course, there should be a warning before the official announcement. Cases of lawful dismissals could be incorrect handling of tasks, consecutive absences, late attendance and unauthorized absence, decreased performance, indifference, procrastination. The employee is made redundant due to force majeure, act of war, civil insurrection, distracted facilities, not due to deliberate action or negligence of the employer. If the employee has completed 30 months of employment, continuous or interrupted, the contract can be terminated in the following cases. The needs are temporary, replacement of absent employee, probationary period, volunteers for 5 years in the army, collective agreement, contract or otherwise. Reaching the retirement age, 65 years for everyone. The employee exhibits behavior such as to render himself liable to dismissal without notice. The employer must proceed with the dismissal within a reasonable time after the event leading to that occurred. Unlawful dismissal reasons can be based on the membership in a union, participation in activities outside of working hours or in working hours with the employer's consent, member of health and safety committees, acting as a representative of the employees, submission or participation in proceedings against an employer for violation of civil or criminal nature laws or regulations, race, color, sex, marital status, religion, political views, ethnic origin, social origin, pregnancy or maternity, parental leave or leave for reasons of force majeure. Last but not least, no person shall be dismissed from his or her work or subjected to adverse treatment by his or her employer for having made a complaint. Those were the most important parts of Cyprus employment policies and legislation that you need to know as you prepare yourself to start your new employment career in Cyprus. More information can be found at the website of the Ministry of Labour, Welfare and Social Insurance and UNCHR Cyprus. For any complaints you may have regarding your employment, you can contact the Department of Labour Relations. Are you ready to start? Do not be afraid, and let's get started.